When you ask me the question as to whether or not the legal system is stacked against the disadvantage, it already assumes that we're not aware there's an imbalance of power between, in the world I inhabit, which is public family law, which is a situation where it's not an argument between a parent and parent about the child. It's not a tug of war with the child in the middle. Instead, it's an argument between the parent of the child and the state, because the state has got involved because they believe the child to be at risk of harm by the parent. The state versus the parent can look to be a David and Goliath type battle, because the professionals are able to be professional and responsible about it, to make notes as they wish. A parent, and the parents I represent tend to be the most impoverished in our society, limited education, limited opportunities, and clearly at sea when it comes to the legal world. And that's why they need a bank of experienced legal aid lawyers to look after them, to advise them on the law, to advise them on the evidence, and to take their instructions. And by the process of having the lawyers involved, then the imbalance of power that might exist in the street is rebalanced when it comes within the court environment. And so by being aware that someone, for example, has a disability, so for example they may be deaf, or they may have a learning disability which may have gone undetected, by being aware of what their particular vulnerabilities are, we can then make sure that we understand and buttress those limitations so that there's an equal playing field between those who make the accusations and the parent who needs and wants to resist them. So what may be unequal in society outside the courtroom, once it's identified and addressed, then we, with our specialism and with the court's expertise, can make sure that we level the argument between the state and the parent. What I've noticed over the course of the last 5 years is that the court and the specialist lawyers are now much more aware of making sure that they probe on behalf of a parent to identify that that parent understands what the legal process is about. And they probe to understand whether there's any reason which might explain why that parent, for example, has difficulty with authority, so not replying to letters, not turning up at meetings. It may not be that they're being stubborn or being an ostrich and sticking their head in the sand when there are concerns about their care of the child. It might be they can't read. It might be it's more than simply not being able to read. It might mean that they've got a learning disability. It might mean that their English isn't their first language, and yet they got no one to turn to translate the letters. So it's the responsibility of those acting, for example, on behalf of parents, to understand if there's another cause other than being cross or angry or upset that might otherwise explain why they have had difficulty coping with some of the concerns about their parenting or coping with being a parent itself. And once we start to probe, and once we start to assess, and that may include a psychiatric assessment, it may include a cognitive assessment, then you can start to understand whether the problems are innate within the person or whether they are a creation and a manifestation of the parent's difficulties in simply being a parent. But you have to ask and you have to probe.